But here we go. So filed on September 9th at 5:17 p.m. Defendant Quamarvious Nichols Supplemental Brief regarding wiretap conversations. Comes now, Defendant Quamarvious Nichols and files a supplemental brief regarding certain wiretap recordings and, in support thereof, shows as follows. Brief factual background and procedural history. So among the charges in the instant indictment is the murder occurring on March 14th, 2022 of Shamel Drinks. Nichols, Stillwell, and Farley were charged with the murder of Shamel Drinks. In March of 2022, the Fulton County District Attorney's Office sought to obtain a wiretap to intercept the communications of Demeke and Garlington. So this footnote here says the District Attorney's Office ostensibly sought the wiretap in Garlington's phone to investigate an alleged plot to kill Fulton County Jail inmate Rayshawn Bennett in February 2022. The wiretap at issue commenced March 11th, 2022, upon the order being signed by Judge Krause. Mr. Nichols is not charged with any crime related to the Rayshawn Bennett stabbing or conspiracy. The wire was up for 55 days and intercepted over 6,000 calls. Holy moly. 6,000 calls. At the time of the challenge conversation, defendants Stillwell and Farley, along with Nichols, were incarcerated in the Fulton County Jail on Rice Street. The particular conversation at issue sub judice is an April 1st, 2022 conversation between Stillwell and Garlington. Nichols was not party to the conversation. This footnote here says the target number for the Garlington wiretap, and we've got a number there. All right, I don't know, whatever. The challenge call was an incoming call to Garlington's phone. The state asserts the call is admissible under GRE 24-801D2E as a statement of a co-conspirator during the course and in furtherance of the charged conspiracies. Nichols challenges that characterization and the call's admissibility against him. The call. So we're going to look at the part that they're taking issue with and want to keep out. On April 1st, 2022, while Stillwell and Nichols were incarcerated on Rice Street, Stillwell reaches out to Garlington. The call lasted almost 14 minutes, the challenge portion coming around 5 minutes and 30 seconds into the call. And we get a footnote here, number 3. This is not an official transcript, but our best efforts to transcribe same. We do not have an unofficial transcript of the entire call available to give to the court. So Garlington says on their transcript, I talked to Funk. I've been with bruh. And he had me on FaceTime like, yo, what's up with Quay? Why the hell? I don't know. Quay on the phone saying something. Like, I don't know if he like, he told Rel. Like, tell buddy goddamn get a lawyer, bruh. We did that ish for him. He pay, you know? You know what I'm saying? And then Shannon says, what? Garlington, yeah, that what Funk told me. He was like, tell homie to chill out, bruh. Shannon, nah, I don't know nothing about all that. Garlington, yeah, that was when y'all was downstairs. He was like, yeah, they was on cell phones, but I didn't say nothing because I know it ain't even, they put a blank and put with a question mark, fair? And they got access to my phone. Shannon, hell nah, we ain't nothing like that going on. I don't think he said no-ish like that though. Now, points in authority. Contrary to the state's assertions, Nichols contests the admissibility against him of this portion of the call. First, of course, it is axiomatic that the proponent of the evidence, in this case the state, has the burden of establishing its admissibility. See State v. Hamilton and Borgelli v. U.S. Second, the state must bear the burden of proof as to each element of the exception. 1, that a conspiracy existed. 2, the conspiracy included declarant and the defendant against whom the statement is offered. And 3, the statement was made in the course of and in furtherance of the conspiracy. See Kemp v. State and U.S. v. Hasper. So listen for these case names tomorrow. I think we'll get some oral arguments about this tomorrow. Nichols has several rejoinders. First, he disputes the existence of a conspiracy of which he was a part. Footnote 4 says, that issue has already been ruled upon and is not an issue now. However, it is noted to make certain it is preserved. Second, he disputes that the conversation was in the course of and in furtherance of the indicted or any conspiracy. In addition, the challenge portion of the conversation contains so-called nested hearsay. That is, hearsay within hearsay. It's the United States v. Mirabel and Brenneman v. Kennecott Corporation. where it says nested hearsay occurs when one declarant testifies as to another declarant's out-of-court statement. But OCGA 24-8-805 provides that hearsay included within hearsay may be admissible if each part of the combined statements conforms with the exception to the hearsay rule. So let's analyze the contested statement, keeping in mind that it is a jailed Stillwell talking with Garlington. See Robbins v. State, individually analyzing each layer of nested hearsay. Working backwards from the current speakers. 1. Garlington is talking to Stillwell. Neither will testify at trial, but both presumably co-conspirators. 2. Garlington tells Stillwell he, Garlington, has talked to Funk. Again, Funk, who is Quamarvious Greer, is another co-conspirator. 3. Garlington tells Stillwell what Funk told him. 4. Funk tells Garlington that Rel told him what Quay, supposedly defendant Nichols, told him. Although it is less than clear, it appears the chain of conversation goes: Rel talks to Nichols. Rel relays Nichols' alleged statement to Funk. Funk tells Garlington. Garlington tells Stillwell. And the capstone of that portion of the conversations is Stillwell, incredulous, which is important, saying, hell nah. So we're not acquiescing, we're not adopting this. Stillwell is saying, hell nah, we ain't nothing like that going on. I don't think he said no ish like that though. As we look at the series of statements, we note that co-conspirator statements are not self-elucidating, and to ensure admissibility, the proponent must present other evidence sufficient to corroborate the declarant's role in the alleged conspiracy. And we've heard a lot of these arguments. We've heard Bruce tackle the same thing. He was kind of going bananas that day cooking. United States v. Sepulveda and U.S. versus Christopher. So harmless error where statement admitted as a co-conspirator statement, where a declarant was not identified, thus could not be found to be a member of the alleged conspiracy. And we get a footnote here that says, again, Nichols maintains that since these are post-arrest statements, they are presumed to be inadmissible, especially against him. Remember, he is not a participant in these conversations. The murder of Shamel Drinks is long over, the party's arrested, and the wiretap seeks to investigate a plot to kill Rayshawn Bennett. So, we spent significant court time arguing this issue. At no point did the state ever identify Rel or claim he was a member, unindicted or otherwise, of any conspiracy. Thus, the original declarant, Rel, breaks the 805 chain, rendering the statement inadmissible against Nichols. Even if a liberal standard applies, Kemp, Supra, at 393, the state is not entitled to a free pass. The judicial determination of the declarant being a part of the conspiracy represents a real limitation on the admissibility of co-conspirator statements. Indeed, as the Christopher Court noted, first, it is unclear who made the statement at issue. Knowledge of the identity of the declarant is essential to establish foundation for admissibility of evidence under this co-conspirator rule, 801 D2E. The witness's uncertainty as to the identity of the declarant barely rises above the level of guesswork, and implicates the concerns which justify the general prohibition on hearsay evidence, namely its lack of trustworthiness. And that's from the Christopher case. So see also United States v. Cummings, reversals for admission of nested hearsay regarding a threat to shoot a witness. In conclusion, the state cannot meet its burden under 801 D2E. Accordingly, these statements are hearsay without an exception. Therefore, we ask the court to deny their admissibility. This 9th day of September of 2024, the Honorable Bruce Harvey. So there we go, you guys. What do you think of that one? And I remember hearing him argue it in court, seeing it on paper. This part here, the original declarant, Rel, not being identified, the state hasn't met their burden of identifying Rel, but he's the initial start of this chain of nested hearsay. So it's broken from the very first step, from the initial declarant. So seeing this in writing, like this other stuff was kind of like, I remember him arguing it, but seeing this in writing, like seals the deal for me. I get it. It lands. So what do you guys think? What do you guys think? And with that being said, I'm going to drop this link one more time in case you want to read the document yourself. Yeah, and I think it's good. Bruce is right. It's a no-brainer. So there you go.